Good morning, everyone. I'm Subathra Mylsamy, welcoming you all again for another episode of Tête-à-Tête, edition 80. Today's discussion is going to be on an interesting topic on trademarks. And intellectual property rights are nothing but the laws which evolve around the creativity and the innovations which people bring out onto the table. So the creativity aspect has been from time immemorial, where mankind has been doing very creative things and we have progressed so far. The basic three categories in which intellectual property rights fall into are trademarks, copyrights, and patents. Today's discussion is going to be on trademarks in a very interesting aspect, and I welcome Sandhya as well on board to take this discussion forward. Hello, Sandhya, and I welcome you.
Thank you, Subhadra. As you rightly said, we are going to simplify all about the trademark. So let's start from the basics. What is the meaning of a trademark?
So, trademark, simply put, is a symbol. It can be a word, it can be a logo, a device mark, or a slogan or a catchphrase, or it can be even a sign which distinguishes goods or services from one person or an entity from another. So such trademarks may include the shape of the goods, their packages, the brand name of products as well. For example, like the word KFC or Tata or Starbucks, these are all like word marks.
Yes.
And in the aspect of symbols, what symbols like the McDonald's, the golden arches are symbols. Correct. And the tick mark of Nike is also a symbol. And in the aspect of a logo, the Nestle logo is also an example. These are all various examples. And in the aspect of slogans, like you have like the Nike slogan which says "Just do it,"
yes.
Or McDonald's slogan which says "I'm loving it." So these are all the aspects of or the differentiations in the aspects of trademarks which can be registered. The whole aspect of registering is the trademark. The basic thing is to keep your entity and to showcase it differently from the others. So you create your own brand and the value for your goods or services or your products.
Okay. Additionally, I would also like to add there's something called a sound mark, like a music piece or a chime or a slogan. I remember the Airtel ringtone composed by famed music director A.R. Rahman is a trademark. So that distinguishes the Airtel. Now, world over, when when the ring goes, that is the Airtel ringtone. So even a sound mark will qualify as a trademark.
Definitely. Yes, absolutely. You're right. In India, it is governed by the Trademarks Act of 1999, which is, of course, read along with the rules and its amendments. And another interesting factor about the trademarks is there are olfactory trademarks which are registered for the aspect of smell. Especially this is for perfumes and people who manufacture perfumery.
Yeah.
So, but in India, we are yet to get registrations to be or laws to be passed for the olfactory trademark.
We all know that the registration of trademark is not mandatory. However, as professionals, we advise all our clients, be it persons, individuals, or business entities, especially startups, to prefer a registering of their trademark, right? There is a general perception that trademark registration is very expensive and so let's not do it. But actually, in reality, trademark registration has a lot of benefits, especially for startups.
Yes.
Let's now discuss on that.
So why this registration? Number one is it gives you a legal ownership, which is either the word, the symbols, or your logos, or the slogan. It is actually an exclusive creation of the person or the brand. So it is very natural that the person who creates it uses it, benefits out of it for further business. In fact, it is used a lot on the commercial aspects. It helps to promote your business and it is used in a lot of business development activities as well. Like for building into your websites or sharing your brochures or being showcasing your products in the stalls. In various categories, it helps to stand out. And any other person or any entity cannot benefit because they cannot infringe or copy into it, And registration of these trademarks also creates a legal ownership for the creator as such. And this will strengthen the registration of the trademark owner in the event of any future litigation. Especially, we see this very happening in startups as well, and also in established businesses which are already even registered their trademark. I think today more and more people are vigilant about using their trademarks as well.
As you rightly pointed out, Subathra, the most important benefit of registering a trademark is creating an exclusive legal right. Now, that is so beneficial because once it is registered, once a trademark is registered, the details of the registration is available on the trademark registry, the trademark portal. So it is basically in public domain. There is public knowledge. Several times we have seen when there are cases of misuse or infringement, the straight away the defense is, oh, we didn't do it intentionally. We didn't know there was a trademark which existed. Now, in fact, for that matter, even when we are incorporating companies, for something as basic as approving or applying for a name approval of a company, there is a built-in mechanism where the name will be approved only once it's subject to a trademark search, whether there is already an existing name. So as professionals, we also run the check before that, and there's a double check there just to make sure that the same name is not provided again. So there are lesser chances of infringement or misuse once a trademark is registered, simply because there are people who know that there is already a trademark in place, so they will be calling for legal action themselves despite that if they use it.
Yes, absolutely. You're right. So one more interesting aspect to know about the trademark is it enhances the credibility and the brand value of your business.
So, Badra, you rightly mentioned that it is an asset. Registering a trademark, it is an asset. In fact, all IPR is an asset, which is so true. It is actually an intangible asset. Intangible because it is not a physical item. An asset because, it offers legal protection as well as enhances credibility and brand value, as you had just mentioned. So even in the books of accounts, it is capitalized as an asset. Now, it's not just treating it as an asset, especially in valuation. Let's say companies are being sold or taken over or in the course of a joint venture, any scheme or merger. These assets will be valued, and then this will only further enhance the valuation of the entity. So it becomes that much more an asset in the course of any compromise or an arrangement scheme.
Yes. You're right. You're absolutely right on the aspects of assets, Sandhya.
We have discussed the importance of registering a trademark, though not mandatory, why it is prudent to register a trademark. We've just initiated our viewers into. Having said that, there are a few things that have to be kept in mind at the time of a trademark registration. Now, this is useful for both first-timers as well as those who have already registered their trademarks. For instance, a basic must know is there are 45 classes of trademarks to be registered in. So if you're applying for a trademark, there are 45 classes. 1 to 34 deals with different types of goods, and the remaining 11 classes deal with different types of services. So while applying, it is very important to go through each and every clause and understand which one the business or the mark or the logo will most closest fall under the category, right?
And adding to it also, Sandhya, since you mentioned about the classes, it is important that once you register, you need to make a combination of classes and register so that it becomes airtight. You cannot just register only under one class or under one section. So it depends upon the business which you do and under what all categories you're going to fall in, and you make an airtight registration done, which not many of them are aware of it. They think under one clause, if you register, it is a full airtight protection.
Yes. Once a trademark is registered, it is valid for 10 years at a time. Thereafter,
Correct.
it has to be renewed. Now,
Yes.
this is important for first timers as well as those who've already registered, because 10 years can be a long period of time.
Long way.
So they have to keep in mind that they have to renew it after 10 years.
Adding to whatever you have said, Sandhya, even individuals can register their trademarks. So it is not necessary that there should be always an entity to register your trademarks, right? For example, actor Shah Rukh Khan has registered the phrase SRK across several classes of trademarks.
Correct.
Similarly, even in the UK, the fashion label called Karen Millen is named after its creator on the same. So even individuals to a large extent can also, register their trademarks. We also see often the symbol R, which indicates that the trademark has been registered. The entry is made in the trademark registry. And also, but the symbol can only be used when the trademark is registered.
After you get the
And not after
approval.
not after just the application has been made or it is before any kind of approval is granted.
An often asked question is, how does one know a product, good or service has been trademarked? How do we know that there is a trademark registration? Your thoughts?
Right. That is a very important question, and always there's confusions around that. So if you see the mark, which is TM, the symbol, it is used when an application is for a registration of trademark and it has been made and it is pending for approval and in the trademark registry. And one can use this symbol after filing in an application for registration of the trademarks and before its approval is granted. So using this kind of a symbol is also an indication to the public saying that I've already applied for a registration, so you can be aware of it. It's like be aware. It's more of awareness to be created on that.
Be aware or
and, yes. And the other thing is which we see often is in various websites or other areas is the symbol R, which is being predominantly used.
Yes.
So the R indicates that the trademark has been registered and the entry is already made in the trademark registry. And by this symbol can be also used on the trademark when it is registered and it is not after application has been made or before the approval is granted. So now the other symbol which we notice often is the S&M symbol, which is actually used for the applications which are filed under the classes of 34 to 45, which is meant for services. Again, this symbol can be used only after the application is for registration and before the approval is granted. So both, if you see, TM and SM can be used for services.
Like with anything under the sun, even trademarks are misused. It is not whether they are misused. There are several instances of misuse. Now,
Yes.
we need to deal with the issue of how the law perceives and deals with such misuse, and there are different kinds of misuse. Please share your thoughts.
Say, there are several instances today where unauthorized usage of the mark, that is whether it is identical or it is deceptively similar to a registered trademark. And in general, it is called as infringement. When you tend to use somebody else's brand or logo or slogan or symbol, it is nothing but it is called as the infringement. Now, this concept of what is this deceptively similar? Now, deceptively similar means that for any average man or a common man, he is going to likelihood of there is going to be confusion between the marks. Then it is, or whether the confusion, whether is this the same product, they have a confusion. Like, for example, if you walk into a supermarket and you have a parachute oil bottle and something on the same replica, I can't say replica, but similar to it, the packaging, and you're in a hurry to pick up, you want actually parachute, but in a hurry you pick up the other bottle also. There is a confusion. So that is called as a deceptively similar mark, So the relief for this or the recourse, it can be sought under the Trademarks Act. Another important factor or a recent case which I came across, which was on the 10th of May, I think it's the Delhi High Court has passed the order in the Starbucks case, where the term for the cold beverage, Frappuccino, was infringed by another company called as the Cafe Art, and they had used the term Frappuccino for their beverages as well. So this was completely opposed by Starbucks and was sued them for the damages. And the order also was passed in favor of Starbucks, clearly stating that the term Frappuccino was coined exclusively only for Starbucks cold beverages. So here, what you need to understand is even the damages paid or the amount which Starbucks has received around, say, about 11 lakhs and odd, is not a great amount on the monetary aspect, but the message which is clearly being sent across, like, hey, look, you cannot do whatever you like with my brand, we are watching out and we are aware of it. I think that is the sense which everybody needs to pick up and get the feeler that whether a big brand or whether a medium-sized brand or whether a small brand, it is important to voice it out.
Another type of misuse of a trademark is based on the concept of passing off. Now, what does this passing off mean? Very simply put, when one person sells his goods as that of another person, that he's passed off these goods as the goods of another person, then it is called passing off. So basically in this, what happens, there is misrepresentation. In infringement, you had mentioned deceptively similar concept. Yes. In passing off, it is done, you have misrepresented your goods as the goods of somebody else. There are several decided case laws that cannot happen. Okay. So what happens to in a case of passing off is it can extend to goods, services, professional activities and services, and business and non-business activities as well. Basically, it dents the goodwill of the original source, right? Yeah. Brand or product or whatever. Okay. And mostly passing off, you see, happens in, there's a general observation, happens in case of trademarks which are unregistered.
True.
Right? While in this context, I would like to just bring on this case of Yahoo Inc., which had, I think, about a decade ago. There was it's one of the landmark cases in passing off. See, we all know Yahoo is an internet search engine with the registered name Yahoo. There was another company which had used the domain name Yahoo India.
Right.
Okay. One would actually think that it's a deceptively similar, but actually the concept here is of passing off, because when a case was filed, the court had ruled that just because you have given a disclaimer in your website saying that this is Yahoo India and it is nothing to do with Yahoo, internet is such a thing that people will go based on the recall value only. So he has passed off Yahoo India for as having being a part of the original Yahoo. And there was an injunction to not use it, and there was some damages as well. I was just mentioning that infringement and passing off are two entirely different types of misuse of trademark. We've discussed the meanings. Please throw light on the defining distinctions.
See, when it comes for the aspect of infringement, it is before you get into the aspect of getting the remedies, what you need to do is, for infringement, your trademark has to be mandatory registered. Then only you can proceed for any kind of remedy. And in passing off, sometimes it can also be, it is unregistered. Usually trademarks are unregistered. So when it comes for the aspect of infringement, usually it is infringement suits are being filed under the Trademarks Act. Correct. For passing off the remedies are generally in the common law, which is the civil or criminal suits are filed.
The law of tort, yeah.
Yes, yeah. And accordingly, you get the compensations or damages are being paid. And also you have either penalties or imprisonments are being given according to the cases. So another form of trademark infringement is knockoffs, which are most often seen in the fashion and accessory industries. So knockoff is nothing but any product which imitates or copies the original and physical appearance of a brand which is already established.
Correct.
Like for example, Prada bag can be passed off with another similar shape, similar color, with everything similar. It's kind of copied, but without the logo on it. That is called as a knockoff. And this, if you see, is way more available or seen in more of the third world countries or developing countries. Here, the people or the public are aware of the huge brand. They know, and they know it is extremely expensive to go and buy such kind of products. So in countries like this or in markets like this, knockoff products are seen in large numbers.
While we just spoke about knockoffs, there is another form of infringement, which is counterfeiting. What is this counterfeiting? Now, the Trademarks Act does not have an express definition of counterfeiting. But when we are talking in general parlance, counterfeiting basically means making something look exactly like the original, tricking people into believing that they are getting the original. Classic example of counterfeiting is currency notes. Right? In fact, the counterfeiting is even the trademark logos are counterfeited to, and they are reproduced exactly perfectly. So you can't even make out the difference between the original and the one that is not.
Yes.
As I said, a classic example is currency counterfeiting. But counterfeiting can also be done for goods.
Yes.
Other than currency notes. But the interesting point to note here is all counterfeits are considered infringements, but the reverse is not true. All infringements are not necessarily counterfeited goods or services. We now come to a very interesting part. I say interesting because we are now looking at metaverse. Thanks to the pandemic, metaverse is, and with Facebook's announcement, it has become a big deal now. So let us initiate people into what metaverse actually is. Simply put, metaverse is a virtual world that mimics the real world, but online, using technologies like, artificial intelligence, augmented reality, so on and so forth. A virtual world where people can work, socialize, live, and carry on their day-to-day activities just like we do it in the real world. For example, I can go into the metaverse, create a version of myself, and then do all the things that I'm doing. But then I'll be doing it online. Yeah. So with people migrating to the metaverse and, things have all the more magnified thanks to the pandemic. Weddings have been conducted. It's not conducting it online. In the metaverse, weddings are happening. Gaming is happening. Concerts are being played through the metaverse. The possibilities are just limitless. And so naturally, the question of intellectual property rights pops up in the metaverse as well. IP is going to be a big deal as we progress or migrate into the metaverse. Let's discuss about that.
It's a very interesting aspect and question, Sandhya. So, as you know, the digital footprints or digital presence seems to be the future nowadays. And most of the establishments like the corporates and startups to every entity today has a website, name it big or small. And that's one of the first initiative to show that you are into a digital space, probably listing out your products and services, etc. So, and obviously, when you enter into a new space of metaverse, which is a digital world or a digital universe, things are absolutely different. Whatever the IP rights which the brand or the company has acquired in the real world or in the real world scenario is also applicable in the meta world, but not to the full extent.
Yes.
It is extremely important that the company which is moving into the metaverse also has its classes being registered accordingly to be there in the digital medium. So if it is just, for example, if they have registered only for the digital aspect of just for website and not enlisted the various goods or services or their products are not being registered under the class, then you will have a problem. So it is important that everything encompasses and you register in total, so that when you transit from this real world to the metaverse, it becomes easy for the entity or the company. So a lot of interesting developments are happening on the metaverse in the IP aspect, though it is in a very nascent stage. So there is no clear-cut clarity yet. And I'm sure in time, as the future goes by, we will have more precedents of cases being established and laws also will come into place to give a clear-cut clarity on the metaverse in the IP rights.
Subathra, you rightly mentioned that the metaverse itself is in a nascent stage. So issues relating to IP protection will unfold and develop as the metaverse itself develops, right? Irrespective of that, we urge and request all our viewers to stay protected with their intellectual property rights, be it trademarks or patents or copyrights, whether it's in the real world or the virtual world. Thank you for joining me in this edition. Meet you again soon. Bye.
Bye.